circulated to the bar. It's dated 3rd April, just to sort of fine tune the manner in which things should be filed, etc. Just make it more easy.
We saw that yesterday. Henceforth, it would be possibly that may not be in sync with the present status. It would be bloated.
Prospectively.
Yes.
Yes, Mr. Gill.
May it please the Lord. My Lord, I propose, my Lord, what fell from your Lordships yesterday when your Lordships were rising. My Lord, I wish to make my Lord, temper the submission which I made in answer to a query that fell from your Lordships. My Lord, would your Lordships kindly permit me to take your Lordships to Bihar Distillery, 97-2 SCC 727, Volume 5A, PDF 91, Para 23. Volume 5.
$76, right?
Yes, my Lord. This is Para 23. Para 23 is a PDF 91. PDF 91. My Lord's got it? Yes. Your Ladyship has it. My Lord, paragraph 23. At PDF page 91. Can I proceed? We are of the respectful and considered opinion that the decision in synthetics did not deal with the aspects which are arising for consideration herein, and that it was mainly concerned with industrial alcohol, that is denatured rectified spirit. While holding that rectified spirit as industrial alcohol, it recognizes at the same time that it can be utilized for obtaining country liquor by diluting it for manufacturing IMFLs. When the decision says that rectified spirit with 95% alcohol content is toxic, what it meant was that if taken as it is harmful and injurious to health. By saying toxic, it did not mean that it cannot be utilized for potable purposes, either by diluting it or by blending it with other items. The undeniable fact is that rectified spirit is both industrial alcohol as well as a liquor, which can be converted into country liquor just by adding water. My Lord, on this I have a submission. Therefore, my Lord, I would most humbly request your Lordships to kindly flag this statement. It is also the basic substance from which IMFLs are made. Denatured rectified spirit, of course, is wholly and exclusively industrial alcohol. This basic factual premise, which is not and cannot be denied by anyone before us. But would your Lordships also like to read the note which comes? I don't know how it came about, my Lord. The footnote.
Footnote, yes. In fact, yesterday when it was being read, I was going to tell the Learned Council that let's see the footnote.
Yes.
I saw the footnote. It's very interesting.
If rectified spirit is toxic and unfit for human consumption, why is it necessary to denature it? Ask the Learned Additional Advocate General for the state of Uttar Pradesh. Denaturing is meant precisely for making what is meant for human consumption unfit for human consumption, he says. Raises certain aspects for consideration herein, which were not raised or considered in synthetics. Take a case where two industries A and B come forward with proposals to manufacture rectified spirit. A says that it proposes to manufacture rectified spirit and then denature it immediately and sell it as industrial alcohol, while B says that it will manufacture rectified spirit and utilize it entirely for obtaining country liquor, Arrack or by whatever other name it may be called, or for manufacturing Indian-made foreign liquors from out of it or to supply it to others for the said purpose. According to synthetics, A is under the exclusive control of the union, and only powers of the state are those as are enumerated in para 86, that is para 86 of synthetics quoted above. But what about B? The rectified spirit manufactured by it is above meant only for potable purposes. Can it yet be called industrial alcohol? can it still be said that the state concerned has no power or authority to control and regulate industry B, and that the union alone will control and regulate it until the potable liquors are manufactured? The union is certainly not interested in or concerned with the manufacture or process of manufacture of country liquor or IMFLs. Does the situation not leave a large enough room for abuse and misuse of rectified spirit? It should be remembered that, according to many states before us, bulk of the rectified spirit produced in their respective states is meant for and is utilized for obtaining or manufacturing potable liquors. Can it be said, even in such a situation, that the state should fold its hands and wait and watch till the potable stage is reached? Yet another and additional circumstance is this: it is not brought to our notice that any notified orders have been issued under 18G of the IDR Act, regulating the sale, disposal, or use of rectified spirit for the purpose of obtaining or manufacturing potable liquors, which means that by virtue of entry 33 of list 3, the states do have the power to legislate on this field not occupied by any law made by the union. It is these and many other situations which have to be taken into consideration and provided for in the interests of law, public health, public revenue, and also the interests of proper delineation of the spheres of the union and states. The line of demarcation can and should be drawn at the stage of clearance stroke removal of the rectified spirit. This is what Mr. Datar was also stressing on when I beg to do the same. Where the removal clearance for the industrial purposes, that is other than the manufacture of potable liquor, the levy of duties of excise and all other control shall be of the union. But where the removal clearance is for obtaining or manufacturing potable liquors, the levy of duties of excise and all other control shall be that of the states. This calls for a joint control and supervision to the process of manufacture of rectified spirit and its use and disposal. We proceed to elaborate. So far as industries engaged in manufacturing rectified spirit meant exclusively for supply to industries, that is, industries other than those engaged in obtaining or manufacture of potable liquors, whether after denaturing it or without denaturing it are concerned, they shall be under the total and exclusive control of the union and be governed by the IDR Act and the rules and the regulations made thereunder. In other words, where the entire rectified spirit is supplied for such industrial purposes, or to the extent it is so supplied as the case may be, the levy of excise duties and all other control, including establishment of industry, shall be that of the union. The power of the states in case of such an industry is only to see and ensure that rectified spirit, whether in the course of its manufacture or after its manufacture, is not diverted or misused for potable purposes. They can make necessary regulations requiring the industry to submit periodical statements of raw material and the finished product and are entitled to verify their correctness. For this purpose, the states will also be entitled to post their staff in the distilleries and levy reasonable regulatory fees to defray the cost of such staff as held by this court and so and so, so and so. So whereas industries engage in the manufacture of rectified spirit exclusively for the purpose of obtaining or manufacturing potable liquors or supplying the same to the government or its nominees for the said purpose are concerned, they shall be under the total and exclusive control of the states in all respects and at all stages, including the establishment of the distillery. In other words, where the entire rectified spirit produce is supplied for potable purposes, or to the extent it is so supplied as the case may be, the levy of excise duties and all other control shall be that of the states. According to the state governments, most of the distilleries fall into this category. So whereas industries engage in the manufacture of rectified spirit, both for the purpose of supplying it to industries other than industries engage in obtaining or manufacturing potable liquors or intoxicating liquors, and for obtaining or manufacturing or supplying it to government persons for obtaining or manufacturing potable liquors are concerned, the following is a position. The power to permit the establishment and regulation and functioning of the distillery is concerned, it shall be the exclusive domain of the union. But so far as the levy of excise duties is concerned, the duties on rectified spirit removed, cleared for supply to industries other than industries engaged in obtaining or manufacturing potable liquors shall be levied by the union, while the duties of excise on rectified spirit cleared, removed for the purpose of obtaining or manufacturing potable liquors shall be levied by the state government concerned. The disposal, that is clearance and removal of rectified spirit in the case of such an industry, shall be under the joint control of the union and the state concerned to ensure evasion of excise duties on rectified.
Against evasion, I think.
Yes. No, my lords, when your lordships kindly come to
just continue reading it. It's good.
Yes, I'll read. It is obvious that in respect of these industries too.
Against evasion. There's a missing word there.
Yes.
It is obvious that in respect of these industries too, the power of the states to take necessary steps to ensure against the misuse or diversion of rectified spirits meant for industrial purposes, that is supplied to industries other than those engaged in obtaining or manufacturing potable liquors to potable purposes, both during and after the manufacture of rectified spirit, continues unaffected. Any rectified spirit supplied, diverted, or utilized for potable purposes for obtaining or manufacturing potable liquor shall be supplied to and or utilized as the case may be in accordance with the state excise enactment concern and the rules and regulations made thereunder. If the state is so advised, it is equally competent to prohibit the use, diversion or supply of rectified spirit for potable purposes. It is advisable, nay necessary, that the union government makes necessary rules and regulations under the IDR Act, directing that no rectified spirit shall be supplied to industries except after denaturing it to save those few industries, other than those industries which are engaged in obtaining or manufacturing potable liquors, where denatured spirit cannot be used for manufacturing purposes. So far as rectified spirit meant for being supplied to or utilized for potable purposes is concerned, it shall be under the exclusive control of the states from the moment it is cleared, removed for that purpose from the distillery, apart from other powers referred to above. The power to permit the establishment of any industry engaged in the manufacture of potable liquors, including IMFLs, beer, country liquor, and other intoxicating drinks, is exclusively vested in the states. The power to prohibit and to regulate the manufacture, production, sale, transport, or consumption of such intoxicating liquors is equally that of the states, as held in Magdal. The writ petition is disposed of with the above. No, my lord, in the query which your lordships had put to me yesterday, my lord, I made a submission that entry 8 covers all varieties of liquor, all varieties of alcohol, except denatured spirit. My lord, I stand by that. But to the further query which your lordships had put, therefore, is the state completely giving up any kind of control over the rectified spirit or which is denatured spirit as such? My lord, in my respectful submission, what I submitted, or what I wanted to submit is that I don't propose to exercise any control over denatured spirit insofar as entry 8 is concerned. But that's not the same thing as saying that I may not do it, my lord, for the purpose of entry 33. And, my lord, because if it doesn't come under entry 8, then it would fall under entry 24, but it will be subject to entry 51. If it is declared as an industry, my lord, if it is not declared as an industry for public purposes, my lord, under entry 52 of list 1, then, my lord, state has complete control anyway on that. Suppose it is not scheduled to the IDR Act at all. State has complete control. But we are looking at a situation where fermentation industry is an item is scheduled to the IDR Act. And therefore, my lord, what happens? Therefore, my lord, I'll have to, the power exercised under entry 84 will still have to be subject to what is mentioned, my lord, in section entry 33. IDR Act is there. But there is a long line of judgments, my lord, which have already been placed before your lordships, including Tikaramji, and thereafter, my lord, finally ending with ITC, Justice Umapal's judgment, that unless there is a notified order under section 18G of the IDR Act, there is no, my lord, legislative measure brought into place by the central government, even in relation to any one of the scheduled industries, which are scheduled to the IDR Act as such. Therefore, my lord, the field is open for the state government, my lord, even for regulatory measures. I am not saying for fiscal purposes, because it doesn't fall under entry 8. And therefore, my lord, I cannot do it. If you look at entry 51 of list 2 and entry 84 of list 1 as it stood prior to the 101st Amendment, my lord, anything other than alcohol for human consumption or liquor for human consumption, my lord, it cannot be taxed by the state. This is what is mentioned.
Therefore, the logical sequitur of your argument is that denatured spirit will fall outside the purview of entry 8.
Yes, yes.
By virtue of the fact that it falls outside entry 8, it must necessarily fall under entry 24.
Correct.
Where there's a declaration under entry 52.
Yes.
It will fall under entry 52. And therefore, that product ultimately is governed by entry 33.
Yes.
In case there's a notified order, then you have to follow the order.
Correct.
Which will be passed in legislation under entry 52.
That's right.
Now, only one question. In fact,
yes.
Manoj, if I'm with my brother, Justice Manoj Mishra's permission, we were both discussing last evening. What happens in the case of an integrated unit? Because that's the point which Brother Manoj Mishra had raised when we were in conversation last evening.
Lord, with respect, my lord, it struck me also. My lord, that's, my lord, because what has been mentioned in Bihar distilleries also. And, my lord, the chart which Mr. Dattar had also provided. It starts out with a unit, my lord, which has to manufacture extra neutral alcohol. And then, my lord, we cannot, but it is not inconceivable that there could be a unit, my lord, which says 90% or 70% of it, I'll take it, I'll use it for portable purposes, but 30% I'll use it for industrial purposes. What happens then? Slightly vexed question, my lord. I'm just with respect, my lord, I'm just suggesting one scenario, my lord. My lord, in my respectful submission, up to extra neutral alcohol, it is, my lord, within the control of the state. What happens, my lord, post production of extra neutral alcohol? That's a product. And therefore, my lord, extra neutral alcohol is also covered by entry 8. Production of extra neutral, there could be cases, my lord, where they produce only ENA. And then, my lord, sell it to other distilleries, my lord, which may blend it and then manufacture Indian-made foreign liquor. That's what happens in many cases also. There are very few units, my lord, which actually manufacture ENA and then also manufacture, my lord, the denatured spirit. Because it's only denatured spirit, my lord, which can be treated as industrial alcohol. That is why, my lord, there could be some reconsideration, my lord, which we respectfully urge that your lordships may do insofar as synthetics and chemicals are concerned. But coming back to this scenario, in my respectful submission, till the production of ENA, the unit still comes under the control, my lord, of a state.
But if it's a unit, as Brother Mishra was suggesting yesterday, Manoj, if there's something further, Brother Manoj, something you can ask on that. Huh?
No,
Please,
there
please.
are occasions where alcohol is used for converting into a substance which is not non-alcoholic, like MEG. For example, there is a process for converting sugar into molasses. Molasses is fermented, alcohol is generated. Alcohol is then converted into MEG. MEG is a polyester raw material. Now that is no longer an alcohol, but it's not a case where 30% is diverted or 70%. It's a case where it is a complete conversion of the raw material. What would be the scenario in such a case?
My lord, in my respectful submission, till the production of, that is where, my lord, the question of clearance comes in. If the clearance is for the purpose of treating it as industrial alcohol, then probably the state would be out of bounds there.
Mr. Attorney and Mr. Solicitor, when you are responding, don't respond right now because since he is in the midst, this is an area because, you know, ultimately our answer should not be very simplistic. We must be conscious of what the permutations and combinations are on the ground. So maybe, you know, because your officers will be instruct you for the union would be very much more conversant with what the exact. So, you know, just when you are taking instruction, just, you know, because ultimately this will be of crucial revenue significance to both sides.
It would be.
But both will have.
We'll take instructions from
Yeah.
the.
As well as.
But this is not an emergency. But I was actually, because he's much
Mr. Datta, any you'd like to share?
Lordship's question. If it's an integrated unit, now integrated meaning the ENA never comes out because when you say central excise duty, you have to decide what is your final product. When you get a license under Rule 44, you say, what is my final product? If my final product is MEG, or it could be isopropyl alcohol, whatever it is never meant to be, then, my lord, it will come under my submission. It will be a fermentation industry other than portable alcohol. It will come under ND 26 directly. Because if it's fermentation industry with portable alcohol, you're out of the amended 26. So you could have a situation where the raw material, what they call the substrate is still molasses. Molasses will be converted into alcohol, but that alcohol is never diverted for human consumption. Straight, it's an integrated process, start to finish. You put molasses here, you get MEG outside. It will be an industry based on fermentation. 26 that's my submission.
No, but I thought what fell from your lordships is something slightly different.
I think
Lordships
that was
were
the lordship's
thinking
question.
about a case where part of the alcohol goes into portable purposes and part of the ENA goes.
No, the whole of the alcohol goes for conversion into a final
No,
product.
The good test is, what is the final product of this unit? If the final product is MEG, then
But if it's a.
Suppose it is a dedicated industry
yes,
for producing MEG,
yes,
then it will have a different understanding.
yes.
Yes.
But suppose it is starting off as a, what is that, extra neutral alcohol producing, and then eventually subject to demand, let us say,
Yes.
you are in that industry, extra neutral alcohol, you are up till the state is still then in control. Thereafter, depending upon how, at the point of removal, what extent you are removing, then state and union control will come in. That's what I think Justice Jiban Reddy had said.
Yes, Lord, your lordship, the answer is, in your lordship's example, my final product will say ENA, extra neutral alcohol.
Your final product will say.
My license will say
Yeah.
extra neutral alcohol. I have to get permission from the state distillery.
Right.
But if
Then
I'm
you-
going to make MEG or if I'm going to make alcohol-based final products, because there's a host of final products which can be based out of alcohol, then I will go for an excise license or now a GST license, and I will never come within the purview of the state law because I'm never making ENA at all. I'm never clearing ENA.
That time you are adding the denatured elements.
Yes, there my
etc.
final product is potable alcohol.
Correct.
That's why what they say is intoxicating liquor is intoxicating liquor. To the extent you denature it, it doesn't cease to be intoxicating. It becomes unfit for human consumption.
That is a little area of
That's
divergence, little area of
area-
divergence between you and
Yes,
Mr. Giri's.
yes, Lord, I would
yes.
still stick to the submission,
Got
Lord,
it,
with
yeah.
respect.
Yes, yes.
Yes. Lord, para 3 of.
But only thing we both say I'm under state control.
That's
So we are denatured. Here I'm under state under entry 8. He's under state in entry 33. But your
Right.
lordship's answer is correct. If the center is notified, then under Mr. Giri's argument, denatured will come under central control,
Right.
under 18G.
Yes.
Lord, subpara 3 of para 23 of Bihar distilleries deals with this aspect. I think when your lordship said integrated, your lordships had in mind a case where up to the stage of production of extra neutral alcohol, Lord, there is no divergence. But after ENA comes into being, part of it is may not diverted for an industrial purpose, either by denaturing it or may not for whatever the process, it has to be denatured. It then becomes industrial alcohol. Justice Jeevan Reddy's judgment, my lord, also speaks about a case where without denaturing it, it is still treated as industrial alcohol because it is not meant for potable purposes at all. In my respectful submission, since ENA is also, my lord, alcohol, which would come under entry 8, it is not inconceivable, my lord, that the state may come out with a, my lord, like in, my lord, intermediate products could also be subject, my lord, to an excise duty or a levy. And therefore, ENA is an intermediate product and not the final product as such. ENA could be subjected to. But where the ENA goes into the manufacture of potable alcohol, I don't subject it to an excise duty at the stage of ENA. I'll probably reserve my right to do it after the final product comes out. But why should I lose out? Why should the state lose out if the control comes under entry 8 and it says production, manufacture? Manufacture is always will not conceive of the final product. Production is of an intermediate stage. And if therefore extra neutral alcohol, even if it is 95% as mentioned in para 74 of synthetics and chemicals, is still a product which is covered by entry 8. I would not by lose my right, not even under entry 8, to tax it before it is cleared, not for industrial purposes. Therefore, my lord, this is my respectful submission. To that extent, subpara 3 or the paragraph 23 may be, my lord, modified by your, in Bihar distilleries also should be modified by your lordships. It's my respectful submission. My lord, just one more aspect, my lord, and I'll complete it. In synthetics and chemicals, my lord, and why? Take synthetics. This may move on synthetics and chemicals. Synthetics and chemicals, my lord. I'll complete my submissions. Synthetics and chemicals is 1991 SEC, page 1. 1990, page 1 SEC. Give the citation for synthetics and chemicals. 109. My lord, it's in volume 5, page 9, PDF page 9. My lord, lordships may come to paragraph 74 at PDF page 54. I don't know. Paragraph 41. I'm going to that. My lord, the objectionable portion, my lord, if I may say so with respect.
Page 50.
PDF page 54, paragraph 74. My lord's got it. Your ladyship has it.
Yes.
It has to be borne in mind that by common standards, ethyl alcohol, which is 95%, is an industrial alcohol. This, my lord, we would respectfully submit. We would most respectfully urge requires reconsideration. Why, Lord? Why should it be questioned, which I ask unto myself is, why should it be treated as an industrial alcohol? It's extra neutral alcohol with a higher strength. It can be used for human consumption. Of course, my lord, by tempering it with water or by any other substance as such. But there is no question of, my lord, it becoming irretrievably unfit for human consumption. That happens only on denaturing. The petitioners and the appellants were manufacturing ethyl alcohol, also known as rectified spirit, fair enough, which is an industrial alcohol. My lord, that doesn't go as a sequit. ISI specification has divided ethyl alcohol into several kinds of alcohol. Beverage and industrial alcohols are clearly and differently treated. Rectified spirit for industrial purposes is defined as spirit purified by distillation having a strength not less than 95% of volume by ethyl alcohol. Dictionaries and technical books would show that rectified spirit is an industrial alcohol and is not potable as such. But then where is a reference, my lord, to the legislations which were existing from 1880 onwards? It appears therefore that industrial alcohol, which is ethyl alcohol, by itself is not only non-potable but is highly toxic. The range of spirits of potable alcohol is from country spirit to whiskey, and ethyl alcohol content varies between 19 to 43%. These standards are according to the ISA specifications. In other words, ethyl alcohol 95% is not alcoholic liquor for human consumption, but can be used as raw material input after processing and substantial dilution in the production of whiskey, gin, country liquor, etc. Entry 8 relates to production also. My lord, why should ethyl alcohol at 95%, which is one of the raw materials, or which is used as a base for preparing different varieties of Indian-made foreign liquor or country liquor for that matter, where only there is a dilution by addition of water, why should it fall outside the purview of alcoholic liquor for human consumption as mentioned in entry 8? But can be used as a raw material input after processing and substantial dilution in the production of whiskey, gin, country liquor, etc. In many decisions, it was held that rectified spirit is not alcohol fit for human consumption. Reference may be made in this connection to so and so, so and so. In this connection, it is important to bear in mind the actual provision of entry 8 of list 2. Entry 8 of list 2 cannot support a tax. The above entry contains the word intoxicating liquor. The meaning of the expression intoxicating liquor has been rightly interpreted by the Bombay High Court in Balsara. The decision of the Bombay High Court is reported in so and so. In that light, perhaps, the observation of Justice Fazal Ali in Balsara's case requires reconsideration. It appears that in the light of the new experience and development, it is necessary to state that intoxicating liquor must mean liquor which is consumable by human being as it is and as such. When the word liquor was used by Justice Fazal Ali, they did not have the awareness of full use of alcohol as industrial alcohol. The point is not that. The boot is on the other foot. Can it be used as potable liquor? It is true that alcohol was used for industrial purposes then also, but the full potentiality of that user was not then comprehended or understood. With the passage of time, meanings do not change, but new experiences give new color to the meaning. In Harshankar's case, A bench of 5 judges have surveyed the previous authorities. That case dealt with the auction of the right to sell portable liquor. The position laid down in that case was that the state had the exclusive privilege or right of manufacturing and selling liquor, and it had the power to hold public auctions for granting the right or privilege to sell liquor, and that traditionally intoxicating liquors were the subject matters of state monopoly, and that there was no fundamental right in the citizen to carry on trade or business in liquor. All the authorities from Kuvarji Barucha to Harshankar dealt with the problems or disputes arising in connection with the sale, auction, licensing or use of portable liquor. Now, my lord, in para 77, Article 47 of the Constitution imposes upon the state the duty to endeavor to bring about a prohibition of the consumption except for medicinal purpose of intoxicating drinks and products which are injurious to health. If the meaning of the expression intoxicating liquor is taken in the wide sense adopted in Balsara's case, it would lead to an anomalous result. Does Article 47 oblige the state to prohibit even such industries as are licensed under the IDR Act, but which manufacture industrial alcohol? This was never intended by the above judgments of the Constitution. It appears to us that the decision in Synthetics and Chemicals Limited, the first one, was not correct on this aspect. Then, my lords, please come to paragraph 81, the conclusion, 81 onwards, my lords. It is not necessary for us here to say anything on the impose on portable alcohol as commonly understood. These are justified by the list of our legislature practice in this country. See the observations of Justice Hidayatullah as the Chief Justice then was in Guruswamy. In that view of the matter, it appears to us that the relevant provisions of the UP Act, AP Act, Tamil Nadu Act, Bombay Prohibition Act, as mentioned hereinbefore, are unconstitutional insofar as these purport to levy a tax or charge imposed upon industrial alcohol, namely alcohol used and usable for industrial purposes. This is where the shoe pinches for us. In our respectful submission, this would be correct. Para 82 could be affirmed if instead of industrial alcohol, it is used as denatured spirit. But if, since in para 74, the lordships have synonymously used industrial alcohol and rectified spirit would be 95% ENA. My lord, this would be incorrect, my lord, in my most humble, respectful submission.
While arriving at this conclusion in paragraph 82,
Minutes.
there must have been a discussion on the content of entry 8, list 2,
There was
on the scope and ambit of that.
para 41, my lord, contains that.
It's at the bottom of 74.
Para 70.
At the bottom.
That I have read. I have read para 74. 67. Yes, my lord. Could your lordships have a look at para 41 and then 67? There's a reference to para 41. There is a reference to it in para 41. That is a PDF page 37.
So according to in para 82, instead of industrial alcohol, if you were to read the word denatured spirit,
That's it.
that would solve
That
the
would suffice. That would suffice. My lord, your ladyship was asking about the
Which
discussion.
para were you saying, Mr. Giri? 44, is it?
41. 41. 41 at PDF page 37. Lord, the question was formulated, but thereafter, my lord, I think it went into. The only question which has to be determined is whether intoxicating liquor in entry 8 in list 2 is confined to portable liquor or includes all liquors. According to the Union of India, in view of the difference of language in entry 8 and entry 51 of list 2, it is reasonably possible to take the view that intoxicating liquors include both liquors. It was submitted by the Union of India that there are no grounds for overruling Balsara, decided in 51 after 38 years, particularly when it has been followed and applied in later decisions. In that case, it upheld the power of the states to completely prohibit, manufacture, sell, etc. potable liquor. It struck down the provisions of the Bombay Act insofar as it imposed restrictions on medicinal and toilet preparations as violative of 19(1)(f) of the Constitution. It is stated that this decision had proceeded on the basis that there could not be a complete prohibition in regard to medicinal preparations containing alcohol. Hence, it was submitted that so far as alcohol not fit for human consumption is concerned, it cannot be held that trade in such an article cannot be considered to be a noxious trade. It will be a noxious trade only when it is produced or manufactured for purposes of human consumption. It is submitted that Indian mica and micanite industries versus state of Bihar. This court was dealing with denatured spirit and had held that Bihar Odisha Excise Act, insofar as it related to denatured spirit, was regulating trade and business in public interest, and that entry 8 of list 2 comprehends all liquors containing alcohol. The state's privilege to completely prohibit or farm out liquor containing alcohol for human consumption does not comprehend, according to the Union of India, a similar right of a state with regard to other intoxicating liquids containing alcohol. According to the Union of India, to so prohibit or collect fee for farming out would be unconstitutional under 19(1)(g) of the Constitution, on the same principle on which the provisions of the Bombay Act were struck down in Balsara. It was further stated on behalf of the Union of India that Parliament has legislative competence with regard to power alcohol, providing for levy of central excise duty. See the central excise, but the discussion remains unconclusive in 41. Mr. Dwivedi says 67, 74 I have already read. 74 I have already read out to your options. Well, in my respectful submission, alcohol fit for in entry 8. Yes, intoxicating liquor would take in, my lord, everything other than denatured spirit in entry 8. And therefore, it would take an extra neutral alcohol also, rectified spirit.
Yes.
My lord, the rest of the areas have been covered.
Thank you, Mr. Giri. Thank you.
Grateful to your options. Deeply grateful.
Is a wider.
It's actually.
Yeah, please.
Mr. Bid.
President, appearing for state of Maharashtra.
We have to only do it on the basis of understanding.
The common thread in 246, 1, 2, and 3 is the subject matter enumerated in these three list models. If the subject matter is not same so far as the list 1 and list 2 are concerned, then there is no fight between these two entries, and state and union can respectively enact the laws based on the subject matters enumerated therein. If we carefully look at the entries given in both, the matters can be in the nature of activities, places, larger concept like industries. And particularly if we look at the present case, the entry 8 in list 2 is a product specific subject which is there, which is intoxicating liquors. If the intoxicating liquors is a product based subject matter based on which the state is competent to make law, whether the entry given in list 1, 52, which is an entry pertaining to industries, and industries also subject to qualification, union to make law, to take control. So therefore, this being debated in these judgments, whether the entry 52 per se is law making enabling entry, or thereafter, until unless law is made, the competence is not driven. But I'll come to that part, Malas. If I'm able to satisfy that the industry, the subject matter, based on which the IRDA was made in 1951, till 1956, the alcohol was not the component of the schedule which is being given therein. And more interestingly, alcohol is not the declared industry there. Fermentation industry is the declared industry, which has got 2 products in that. Similarly, if you look at the chemical industry, it has got 15 or 16 products. If you look at the steel industry, it has got the 16 and 17 products. So, my first submission is that when we closely read the entry, and that has survived since last 75 years, now, this is my respectful submission. A product-based legislation which has been made pre-constitution time also, those are the state excise laws, and then the subsequent rules which are there. All the provisions in these acts pertains to industrial alcohol, or the intoxicating alcohol. There can be different stages. There can be different activities which are pertaining to those products. And in order to regulate and control, a different procedure has been prescribed in states. Nowhere Industrial Development Act has dealt with what is being dealt with the acts which we are talking of, state laws. There can be a difference between the industrial license and there can be a difference between the product license. At the industry level, the governance and regulation can be different, which stems from the provisions of the Industrial Development Act. At a product level, the regulation and governance can be different, which stems from these excise laws. Neither union at any stage made an attempt that we want to govern a product and therefore we'll specify that how alcohol is to be manufactured, stored, moved, removed, and to be denatured, renatured. Nothing has been dealt with. Our declaration in section 2 of the Industrial Development Act very clearly says, union wants to take a control of the industries given in the schedule. Nothing more, nothing less. If we see the index of the entire Industrial Development Act, that talks of the councils to be framed. Councils are going to guide that how the production of the country to be increased. Subsequent chapter says that how the ownership is to be looked into. After a particular date, the industries are existing, industrial licenses to be taken. And 18G is the only one category, and that's also not the category is unconditioned. That says if the union think it is to be determined fair price, it is to be distributed in a particular manner, then under 18G, some category is to be, some notification is issued to be certified product funds. Now, to look at this, is there a conflict between entry 52 and entry 8 if we look it from the point of view And whether in last 75 years, at any point, at any stage, the issue has arisen in this context, the answer with great respect is no. Today, there is no law made by union, and that's the reason para 41 of the synthetic, union agreed to this position, saying that both the products are covered in entry 8. That was the basis if we read para 41. So it is not that there is no basis of para 41, and today union says that no, my position is that so far as denatured spirit or industrial alcohol is covered is in the union list. That's not the issue. To make this submission good, I'll rely on I could mail it in the morning, but I'll give a gist of this case. Vijay Kumar Sharma versus 1992 SCC 562.
Submission?
1990.
I'm sorry, 1990.
Can you just formulate the submission? Because
Yes.
what is exactly
My submission is this, Malas,
Yes.
that entry 8 on a standalone basis, dealing with intoxicating alcohols, give power to the state government to make laws on it, and there is no conflict with the entry 52 in list 1, Malas. Because entry 52, list 1, deals with the subject matter pertaining to industries given in schedule 1, which is an industry-based legislative competence to be seen. Whereas in the list 8, entry 8, list 2, the product-based legislative matter is provided, which is to be seen in 246, 1, 2, and 3, Malas. And this issue came before one of the constitutional benches. And the test prescribed was whether the subject is same in both. And if I'm able to satisfy, and my lords are with
What
me.
is the industry?
Yes.
The product in this respect, the product is a product of an industry.
Yes, Malas.
Which is declared under entry 52. Then what happens?
Malas, if the industry per se, and I'm grateful, Malas, and that's the reason why this debate came, that what is the industry means and why it was in these two judgments specifically restricted, it's to manufacture and not pre-manufacture, not post-manufacture. So the industry per se, Malas, if we look at it, even if the product is given, and if we look at the law which has been framed, a law which has been framed is not at the product level which has been framed, which is framed under the entry 8 in these in the state subjects, or in the state laws. Now the industry to be seen for the purpose, even if the product, one of the product is given.
Industry is fermentation.
Industry is fermentation. And what are the laws which can be made about the industry are, and which are very, very clearly enumerated in the act itself of the Industrial Development Act. And if we'll see the amendment in 2016, precisely give the reason, say that under the 1951 Act, we have to look at the policy to be made in regard to the industries which are enumerated in Schedule 1, not regarding the product. There is not even a single provision in the Act which deals with the a particular product, how the product is to be regulated. That's not the provision which has been there. The judgment which I'm referring to, I'll just quickly give a background. And if we see, the entry 52 in list 1, the industry which is to be seen, is not an independent entry, a law to be framed by Parliament for a reason, to take control. That's a law which is to be framed in terms of the entry. It's not straight away saying that the law can be made and therefore any industry can be prescribed in this. So there has to be law specifying to take control of that particular industry, which is this particular Act of 1951 is. So it's not an open-ended power or legislative competence which can be driven out of this entry. Whereas if we look at entry 8, it is neither subject to any other entry. It is clear open power which is given to state. State, since pre-independence, there are multiple, the excise laws which are prevailing, which has been amended thereafter and has been sustained over a period of time. I'll come to the synthetic part.
And under entry 8, according to you, what stages can the state regulate?
Plus
at what point does it cross entry 8 and what is comprehended in entry 8?
Yes, I'm grateful. Plus, thankfully, like the entry 27 and 28, where gas and gas works is given. Entry 8 has taken care of trade and commerce in that particular product also. If we see,
Entry 33.
no, Malas, for the time being, I'm not coming third. Kindly see entry 8 again with me, Malas, for a minute. Because one of the angle in the industry,
Because it says, that is to say,
yes,
production, supply, distribution.
yes. So if I, for understanding purposes, say what does a trade commerce means, Malas? Trade commerce potentially can mean the production, manufacture, possession, transport, purchase, and sale. And purchase is an interesting entry in entry 8 itself of list 2, Malas. Kindly see intoxicating liquors. That is to say, production, manufacture, possession, transport, purchase, and sale of intoxicating liquor. Any activity which pertains to this particular product, and there is a reason behind it why this is being prescribed like this. My lords are aware, and it's been debated in last 2 days. Industries are primarily given under entry 24 in list 2. That's the principal entry for industries. There are 2 slices in that. The first slice was the one which I'm talking of, entry 8, on the same day when the constitution was made. Second slice which has been made is out of leftover entry of 24, and the entry 51 was carved out thereafter. And so far as this very product, intoxicating liquor, is concerned, that was sliced out in the beginning itself in the form of entry 8. This was not available in 24 anymore. And therefore, till 1956, till the time the fermentation industry was not the part of the industry declared there, and the alcohol being there, this was not a debate. And that is the reason when we see, I'll show the provision of both the acts, the State Act as well as the Union Act, and the declaration which has been given. That slice which has been carved out in entry 8 is not available in entry 51 is my respectful submission, and that's a discussion. In one of the McDowell judgment, this was precisely the argument Sorabji made before the court, which was accepted by the court. I'll show that argument. Sorry, 52 minutes. 52. So that's once that position is taken, and do we really need to trace the originals? And today we are seeing in the capacity of resolving a dispute. I'll urge and request my lords to see that if it is to be framed today, why
will intoxicating liquor in your submission include denatured alcohol also?
Yes, Malas, I'll give my reasons to that also. First of all, I can straight come to that, Malas. And why do we need to split it? 8 is intoxicating liquors. It is the plural. There was no need to use this. And there is why this is being done is because
then if they wanted to include denatured alcohol, they would have used the expression liquors. Why did this use the word intoxicating?
It's because the content of alcohol is a measure of a product which is liquor which is to come out. That what is the alcoholic strength of a particular product is going to be determinative factor that whether it is intoxicating or not. Intoxication, a percentage can vary, the composition of a product can vary, and therefore the intoxicating word is used because the liquor primarily, that's what the understanding is, in my respectful submission. There is some debate on this. And why this the other product which is denatured is not carved out of this is because all the stages.
What is meant by intoxicating?
Well, the intoxicating certainly means that if it has ability to manipulate the senses of a consumer. Right. So in that case, and that can be in how it is consumed, at what stage consumed can be debatable. But to get into a scientific measure to determine that the intoxication, not in the common understanding to be seen and we need to derive with great respect, may not be the reason. The answer seems to be in the entry itself. Denatured spirit may arise at some stage of all the activities which are given therein. It may be at a production stage, it may be a manufacturer stage, it may be a possession stage, a transportation stage. Wherever the makers thought it fit that we have to give a taxing power, it linked with the human consumption. Like in opium, if we see, opium regulation is given in the union list, but taxing entry is given in the state list. So, in a federal structure, the understanding was that these units can operate on their own. The states can operate on their own from the terms of the financial resources, from the law and order situation, and therefore these were carved out. That the regulatory requirements so far as anything coming out of entry 8, which may have a law and order situation, because of alcohol, because we have seen the numerous cases and some coded distillery and all they have raised, that is a social issue and so on and so forth. And there is some requirement of a society order to be maintained. It has been, the governance has been given to the state. And union has been given to power because there's a revenue calculation for whatever may be the reason. For human consumption, excise duty is there. Sales tax, entry tax, GST, today's state can do that. After 101st Amendment, there is no restraint except the restraint on the excise duty. That part is there. Now to say that we'll read entry 52 and where the law has been framed to take control, it is not an open-ended entry to say that 52 means the union can do anything with a particular industry. It is only with the objective that the control is to be taken. And that's what we see section 11 and 12 of Industrial Development Regulation Act. They say after this, the particular date, the industrial license is to be taken because union wants to, today, how much FDI to come into it. That's the precise reason given in their objective, saying that how much of production of this particular product should be carried out in India, what should be the land size, what should be the capital size, a foreign investment permitted or not, who should be the owner, which industry can be taken control of. That can be very one. As a matter of fact, that has been done by that law. And supposing down. Please, Melissa.
You have referred to 246 to say that these lists operate on various subjects.
Matters, Melissa. Yes. Yes. Kindly see 246(1) for a minute.
Yes.
Anything, notwithstanding anything contained in clause 2(3), Parliament has exclusive power to make laws with respect to any of the matters enumerated.
So far as entry 8 is concerned,
Yes.
it is a product-based enumeration.
Yes, Melissa.
And the term intoxicating liquor is used twice in entry 8.
Please, Melissa.
So there has to be given some meaning and understanding that it's a product-based entry.
Please, Melissa.
And so far as the industry itself is concerned,
Yes.
you're talking about the IDEA Act,
Yes.
where it talks about that it is expedient in public interest that union should take under its control industry specified in the first schedule.
Absolutely.
So you are trying to make a distinction that when you take over industries,
Yes.
it may have nothing to do with a particular product unless it is said that this particular industry and this particular product. Of
Yes.
course, the schedule to some extent gives a.
Yes, it gives a pointer and then 18G, Melissa. 18G specifically says wherever a particular product for some reason is to be regulated, 18G is a power which is being given to the state. It's not that merely because a product related regulation has been given in entry 8, that by virtue of the law framed by virtue of entry 52 state union is denuded. No, 18G is a power which can be given. And why I'm saying is today we have experience of 75 years. If we see what the law says with the Industrial Development Act says, wherever it has been, and 18G also is not independent. When we read, there is a reason behind 18G. It has survived. Today, when it's if we see the referral order, the start point is a paint manufacturer in UP said, I want to buy a denatured spirit. I've been asked to take a form FL41. And he says, I have nothing to do with it. I don't want form for them. Therefore, the law is not applicable to me. That's the start point. Now, all paint manufacturers, all the consumers of denatured spirit are today in one way or the other required to have some kind of a control in possession, use, and therefore need to confirm back that the actual use being there. And the answer is very simple. excise duty on alcoholic human consumption liquor is 350% in state of Maharashtra. If today denatured spirit for some reason can be renatured, can be converted to consumable, and I'll show that the BIS standards which are there, which can be done, then there is no 350% which is to be paid. So and these are instances after instances which has been taken note of by the state, and the notices have been issued to this, beside the tragedies which are there because there's the methyl alcohol is being used instead of ethyl alcohol in those cases, is being there. So straight away the answer is that if the state is not going to regulate that, and if the alcohol industry, if I say that the particularly treated as industry, the word is alcohol in the fermentation process, a control is given to union with the law we have in place, what happened to those kind of positions, which as a matter of fact has been recorded? And that was the very precise basis of aim and object what Mr. Datar read for 2016 amendment. That was the reason. They said we are making this where the human consumption has been taken out of that in spite of whatever the law laid down till 2016. And the reasoning given in the last para is very clear. We want to have a policy control in this, which through the IRDA, which has been done. And never in last 75 years, any attempt has been made to say that the particular industry in a particular state, we want to regulate, control the possession and manufacturing, everything. Not been done. Except these two judgments where say the question came, the industry means what? And there also, it was restricted that because entry 92 talks of control by the union. And the provisions of IRDA give some sense and link with this control by union to the manufacture and production. Because Government of India want to have an overall view that a particular commodity, how the steel is manufactured in India, how much steel consumption is available in India, how much import should be permitted in India, how much of foreign investment should be permitted in India. That can be done through IRDA. But somebody say that each steel product specification should be regulated. We have BIS standards, Standard of Weights Measures Act, and the multiple other laws are there. And particularly when we look at the industry which has been given in this schedule, industry has got 17 products. Assuming one product is given herein. And the subject matter based on places, activity are not new. If we look at 5 and 6, ammunition manufacturing, firearm manufacturing, that has been given to the union in list 5 and list 6. This is the way it has been structured. Now to say, we will not look at list 8, because it's an industry of alcohol, although it's the industry of alcohol is nothing there, it's a fermentation industry which has been declared, which has a component of alcohol or product of alcohol in that. It is not the object. The alcohol word written therein and every species of alcohol get covered and therefore the state is taken out. With great respect, that's not the purpose. And I'll give a facts of this Vijay Kumar, which I'm saying, Malaj.
In 18G, actually, 18G.
Yes, sir.
The IDRA can be partly traceable to entry 52 of list 1.
Please.
Some provisions may be traceable to entry 33 of list 3 also.
Yes.
That's perfectly permissible to Parliament. So when Parliament says you must have a registration of the establishment, licensing, power to take over management, that is Parliament's power of control, which you find in the first few sections of the Act.
I agree.
If you just look at, if you look at the index to the Act,
yes,
it'll say, Chapter 3, Regulation of Scheduled Industries, registration.
Yes.
Revocation of registration, licensing, license of producing.
Yes.
Power of central government to specify requirements, revocation and amendment of licenses.
Yes.
Power to investigate into the affairs of a company in liquidation. Then
yes.
comes Chapter 3A.
Yes.
Direct management or control of industrial undertakings by central government in certain cases. Chapter 3AA, management or control.
Yes.
Power to provide relief to certain industrial undertakings.
Yes.
3AC, liquidation or reconstruction of companies.
Yes.
Right? Up to there.
Yes.
It may be traceable to entry 52 of list 1.
Yes.
Now, when it comes to Chapter 3B,
yes,
control of supply, distribution, price, etc. of certain articles, 18G is what we are concerned with.
Yes.
That is referable to entry 33 of list 3, except that entry 33 also covers production. Entry 33 covers production, supply, distribution. Section 18G doesn't cover production. It only covers trade, commerce, supply, and distribution.
And reason is very obvious,
right. Therefore, 18G is Parliament's in exercise of Parliament's power under entry 33 of list 3. Right?
Please.
Now, therefore, conceivably, Parliament can control trade or commerce in. And though you are saying that IDRA is industry based and entry 8 is product based, the section 18G is product based.
Yes, I'll come to the 18.
Certain articles,
Yes.
which
As on today-
which are referred to in the schedule.
Yes.
So, in relation to 18G, the IDRA also becomes product based. The point which is, however, we made by the others, by the lawyers who appeared before you, was of some weight, which is that 18G will come into existence, will apply provided there's a notified order.
Please, Manoj.
Until date, the union government has never made a
That's
notified order,
Tikaramji, Manoj.
right?
Yes.
So, but short of that, for us to say that article entry 8 will cover all kinds of alcohol, irrespective of whether it is denatured, otherwise, would be a little extreme. It would be maybe a very extreme view of entry 8. The better view may possibly be, subject to hearing the other side, that entry 8 will not cover
Yes, certainly. That's my argument, which I'm.
denatured spirit.
Yes, well, I'll come to that part. If we see entry 33 also doesn't deal with the industry, deal with the products.
And theoretically, Parliament, once it notifies an industry as declares an industry to be a controlled industry,
Yes.
it can even deal with the articles of that industry. It has a power then to deal even with the products. Question is whether Parliament delegate, that is, the central government has done so. So long as it doesn't do so, the power is still with the states under entry 33.
Kindly see 18G with me for a minute.
Except in relation to denatured spirit. On denatured spirit,
Yes.
the state's power may be restricted.
I'll try and persuade my lords. Kindly see, first of all, my lords are saying by virtue of 18G, product-specific power also come to.
But even on denatured spirit, the state's power may arise under entry 33. That's not a fiscal entry.
Yes, so if.
Right? Even in regard to denatured spirit,
Yes.
which goes into entry 52,
Yes.
the states still have a regulatory power under entry 33.
Yes.
For instance, they can ensure against diversion, they can lay down various regulatory norms. The state is, and for that purpose, it may demand a fee.
Yes, that certainly can be done, Melissa. I have no difficulty on that part, Melissa.
So
So far as.
what is your wider submission?
Well,
from what everybody else has argued, what is it? Because
My wider submission is that that so far as entry 24 is concerned, which pertains to list 2 industry, the industry is in the state list. A carve out is 7 and 52 of list 1.
right.
Whereas if entry 8 is to be seen, which was existing right from the day 1 in the constitution, that as a matter of fact, along with the trade and commerce, what we call it, possession, sale, control, and purchase is only in that entry. Purchase is nowhere else. The reason for that is that if any controlled commodity is to be purchased like by the paint industry, in that case, the FL 41 can be asked for under the state law. And that's why the word purchase is there. In no other entry, the word purchase is there. It's only in entry 8. But having said that.
That's one thing. I mean, what is Maharashtra's, what's the submission actually?
Well, my submission is one, the state, as a state of Maharashtra, we are competent to make the law which we have made and which we, as on today, are exercising, that the denatured spirit is covered under the entry 8 of list 2. That's my submission. And the reason for that is twofold. One is a standalone list 8 gives the state power. And IRDA, by virtue of entry 52, is not overstepping that domain. That's my first argument. Second argument is, even if you
state can make law on denatured spirits.
Yes, Manoj. By virtue of same being part of intoxicating liquors, Manoj. And
that is Mr. Dwivedi's submission also.
Yes, Manoj. Originally Mr. Dwivedi.
Relying on Balsara.
Yes, Balsara. Second submission is, Manoj, that entry 51, entry 52 of list 1 is not a unblocked entry. It is blocked and a specific purpose controlled by union of an industry, a law is to be made, which is the IRDA.
Not, what do you,
I'm sorry. The
not an unblocked entry, what do you mean? by that?
Yes, unblocked means it's not an unbridled power that in regard to any industry, the union can make. That power is in 24. Union need to make a law to take control of that industry, the law pertaining to take control, and that's section 2 declaration of the IRDA, my lords. If I can read quickly the entry itself, my lords have seen on numerous occasions. Industry, the control of which by union is declared by parliament. It is not simpliciter industry.
Right.
That is
And
why-
otherwise, the industry is covered under entry 24 of list 2, Malas.
That is the point. What is the nature of industry under which the center
Fermentation
parliament
industry.
can make?
Yes, Malas.
You have rightly said fermentation industries.
Yes.
Even if you see this 26 fermentation industry, there is a twofold
Yes,
classification.
Malas.
One, it is alcohol. The other is
Others.
other products of fermentation industry. Under alcohol, they have again made a classification. Alcohol which is potable,
Yes.
alcohol which is not potable.
Yes, Malas.
That means it's an indication
Yes.
that alcohol is potable only is under entry 8.
Malas, the,
Anything not potable,
yes.
the parliament has the powers in view of entry 52 list 1 and entry 24 of list 2.
My respectful submission, Malas, even if we look at that indication sum which has been given, if it is an industry specific and a product which has been already given entry 8, will that entry given in that schedule will exclude one of the product out of the product which has been given in entry 8 with great respect and Malas,
It is not the product, it is a classification of a product.
this is the subject matter. The subject matter of framing law.
But then, Mr. Balvi Singh,
Yeah.
your submission is not at variance with what Mr. Datar or Mr. Dwivedi argued. Because their contention also was that denatured spirit also
Yes.
falls in entry 8, step 1.
Yes.
Because it falls in step 8, in entry 8, it can't fall in entry 24,
Yes.
right?
Yes.
Because following Calcutta gas.
Yes.
If it can't fall in entry 24, there's no question of it being taken out for the purpose of entry 52,
Yes.
right? That was the line going
What
from
submission
entry
is that?
8 to entry 24 to entry 52. And therefore, according to them, this retains the power of the state under entry 8.
Yes. So
So your submission is not different from that.
effectively not different, but I am trying to take maybe a step prior to that.
Content of entry 8.
Intoxicatedly.
So I'm only on the subject matter, Malas. I'll just rely on 2 judgments.
I think that, while entry 8 is product based, entry 52 is industry based.
Industry based, Malas. And today
There's an answer to it that, entry, IDRA is both product based and industry based. In section 18G, it's product based. There are some parts of it which are industry based, of course.
Today when we look at the declaration which is given in section 2, the similar declaration, I can quickly tell the facts of this case before in Karnataka, the contract carriage was nationalized. In 1976, law was framed and all private contract carriage was taken control of by the government by a law. This was in 1976, went to Supreme Court. Supreme Court identified 7 judges before this court, and court said that state is competent, identified the entry with the acquisition and requisition entry in entry 42 in concurrent list. Not tracing to industry, but tracing to saying that the acquisition of property or acquisition of property in 42 is there. 1988 Motor Vehicle Act came in. One of the parties went to the state authority RTO saying that now the 1988 Motor Vehicle Act has come, please give me the registration or license. This issue came to the Honorable Court again. There the issue came that 1988 a Central Act has come in and therefore these provisions are in conflict. Looking at this provision and the Motor Vehicle Act was also traced to entry 35 of concurrent list. So both the conflicting entries were in the state list. This Honorable Court said that just to explain, the entry 35 was pertaining to mechanical vehicles. So therefore, 2 conflicting entries were requisition and acquisition of property and mechanical vehicle. These were 2 conflicting entries for Motor Vehicle Act of 1988 and 1970, the acquisition law. This Honorable Court said, if the subject matter is not the same, even if there is an overlap, then they independently they can prevail. today to oust the jurisdiction of the state by carving out the denatured alcohol out of entry 8, relying on a schedule, a product given a schedule with respect, well, this is an independent subject. There the industry has been defined. That's what he argues.
No, I think we'll conclude at this point. We'll take Mr. Faraswat. Yes, Mr. Faraswat. Thank you, Mr. Baldi.
Well, just one part I want to read. From the IS, Mr. Giri argued that so far as the state of Kerala is concerned, that the denatured cannot be converted to renatured. BIS standard, which in para 74, which we looked into in synthetics, simply said anything over 95% is industrial alcohol, although it should denatured. This was taken note of by BIS standards. I have placed on record. I'll give the page numbers also. They clearly noted that there can be a complete denaturing, there can be a special denaturing. As a matter of fact, where the government has faced a problem is special denaturing, which can be again converted into renaturing, because this was specified for some 25 industries. And there are live experiences that has been converted and sold in the market as a country liquor. Based on that finding, it has been given that the BIS standard which are given is in straight conflict with para 74. That's been a forward which has been by BIS which has been given. So therefore, Mr. Datar pointed out.
In the case of a special denaturing,
yes,
capable of being used again, is capable of being renatured.
Yes, and it's a only boiling point is to be changed. They note that it's a very simple process. And they specify also industry. If my laws permit, I can quickly show that BIS standards which are prescribed this. And as a matter of fact, they said it's been happening. And they specified even what is the boiling point and what the change is going to take place, Malas. I just quickly show only one page and then I'm done with that, Malas. I filed my written submission in volume IK, Malas. And 1K, sorry. And page 129, which is PDF 129. PDF 130.
BIS standard. What are you referring to?
I'm referring to only the forward of those standards where this problem was specifically noted and what is the.
Where do we get it? Where do we get it? Volume?
Volume 1K, PDF 130, 130.
Say, now it's not there.
I can quickly read that. There's only 2 paras. I can just quickly read. The third para is completely denatured alcohol, which is CD, and specially denatured alcohol ST formulations are set out in this standard with a specific composition. Both CD and ST formulations are made from the spirit in accordance with the international trade practices. These resulting products are not fit for human consumption. Instead, the products are intended for industrial use. CD, that is completely denatured alcohol, is composed of alcohol and specified denaturants that cannot be easily removed by a simple process and can be used in a number of industrial use. As the denaturants cannot be easily or economically removed, CD is considered to be low risk of diversion or abuse. ST, which is the specifically denatured alcohol, is composed of alcohol and specified denaturants that are more readily removed by simple chemical process, while specifically denatured spirit is not fit for human consumption by virtue of denaturants used to denature the product. It can, through certain recovery process, be made portable. As a result, its use and control through the registration of users, like the paint industry. Otherwise, everybody user is going to go out. Today, there is no mechanism by virtue of which the user industry, what they do with the denatured spirit which they procure. There is no control except the state laws which are controlling, like through licensing, returns filed by them. There is no law which prevails. And just one more page on this one, how the formula of these two are given, and look at the extent by which these two type of categories of product, PDF 139. A category, the formula for denatured alcohol. A category is completely denatured alcohol, which are safe, are low in risk. Look at B, specifically denatured alcohol. These are the products which are there. And these are regularly being purchased and sold and consumed by the user industry models. And this is under the high risk, as a matter of fact, which has been found to be a problematic area.
Genuity in making what is non-portable portable.
Yes, but as a straight, I asked this question that why somebody is going to do this. The 350% of the excise duty is saved straight on this one.
Intoxicating.
Even plastic soda.
Medical products like cough syrup.
So you're done now?
That's
Thank you.
great.
So, Mr. Paras, we'll take your submission, 15 minutes or so. You can argue to your heart's content, but about 15 minutes. That will then request the other side to start.
5 minutes. 5 minutes.
क्या बहस करेंगे?
हाँ सर.
इंटरव्यू